Okay, let's unpack this. How does dissolving a marriage actually work in Islamic law? Across different traditions and how things look today. This deep dive is based on some really detailed documents. They've been generously made available to students by the University of London, which is fantastic. And just so you know, we're using these sources purely for educational purposes. This deep dive is brought to you by Sinorbit Academy, Sri Lanka. And hey, for all of you getting ready for exams using this, good luck. Seriously. Our mission today is to navigate these methods, sometimes complex, sometimes even surprising ways marriages can end under Islamic law. We want to pull out the essential knowledge so you feel really well informed.
It's definitely a substantial topic. It's got a rich history, and like you said, it's really evolving with modern applications. Islamic law offers several quite distinct ways to dissolve a marriage, and the source material really highlights how approaches vary, between different schools of thought, and especially with these profound modern reforms we're seeing.
Okay, so let's jump right in. The method probably most people think of first, the husband's power, talaq.
Correct. Talaq. That's the husband's unilateral repudiation of the wife. In classical Islamic law, particularly within the Sunni tradition, the husband generally had the right to end the marriage just by pronouncing the divorce, often without needing a court's okay or even giving a reason. This unilateral power was really a defining feature back then.
And even within talaq, there are different flavors, right? The sources mention forms based on the Sunnah, the Prophet's tradition.
Yes, exactly. The forms considered most in line with the Sunnah. So the most approved form involves just a single pronouncement of talaq. And it has to be during a time when the wife isn't menstruating a period of purity. This is then followed by the iddah. That's the waiting period. Typically 3 menstrual cycles or until delivery if she's pregnant. The key thing here, and it's really important, is that during this iddah, the husband can actually revoke the divorce. He can say it explicitly, or it can even be implied, like just by resuming marital relations. And his duties, things like maintenance, they continue during the iddah. Inheritance rights also remain intact. Now, if the iddah period finishes without him revoking it, then the talaq becomes irrevocable. But crucially, only to a lesser degree, meaning they can still get back together, but they'd need a brand new marriage contract.
Okay, so that single revocable talaq with the iddah, it really builds in a chance for reconciliation. What about the other sunnah form, the good form?
Right, the good form. This involves pronouncing 3 talaqs, but spaced out over 3 successive periods of purity. So 1 pronouncement per period. The really critical moment is that 3rd pronouncement. Once that 3rd talaq happens, the divorce becomes irrevocable to the greater extent. What that means is the wife cannot remarry her former husband unless she first marries another man. That second marriage legally ends, and she completes the iddah from that second husband. It's a significant barrier. Now, revocation is possible during the iddah after the 1st or 2nd talaq, just like the other form, but not after the 3rd. That one's final in that sense. There's also a slight difference on maintenance during iddah after a 3rd talaq. The Hanafi school generally says yes, the husband still provides maintenance. Other schools usually say no unless the wife is pregnant.
Interesting. So these sunnah forms, they have stages, almost like built-in pauses for reflection. How does the Shia view differ on talaq?
Well, the Ithna Shari Shia school, they're generally stricter about what counts as a valid talaq. They primarily only recognize these 2 sunnah forms we just discussed. And crucially, they have specific procedural requirements. You need to use precise Arabic words. And this is key. 2 adult male Muslim witnesses, known for their good character, must be present when the talaq is pronounced. This requirement for witnesses, it's a major procedural safeguard that wasn't generally required in classical Sunni law for talaq.
Okay, now the source material also talks about something called talaq al-bid'ah. Just the name, bid'ah, meaning innovation, suggests it's problematic.
It is. It's generally considered an innovation and often morally reprehensible. Yet, historically, Sunni Islam widely recognized it as legally valid, even if sinful. The most common example you hear about is pronouncing 3 talaqs all at once, like say, I divorce you 3 times, or just say, I divorce you 3 times in a row, bang, bang, bang. Another form of bid'ah is a conditional repudiation, like, if you leave the house without my permission, you are divorced, that kind of thing.
And the classical legal view on this talaq al-bid'ah was, it actually worked. It was valid.
Yes, that's the tricky part. Despite being viewed as sinful, the dominant classical Sunni view was that it was legally effective. A triple pronouncement made all at once resulted in an immediate, instantly irrevocable divorce to the greater extent. So, no iddah period for the husband to revoke it. No chance of remarriage without that intervening marriage to someone else we mentioned. Very final, very sudden.
Right, and this is where we see a really massive modern reform, isn't it? That classical effect of talaq al-bida, especially the instant triple talaq, has been drastically changed in many places.
Absolutely. This is one of the most widespread legislative reforms you see across the Muslim world regarding divorce law. Many, many countries have passed laws saying that a triple talaq pronounced at one time will only count as a single revocable talaq. This is a fundamental shift. It's huge. Because it means most of these divorces, which used to be instantly final, are now revocable during the iddah period. It opens the door again for reconciliation.
So they didn't make the pronouncement itself invalid, but they changed its legal consequence, made it less drastic. Why did they take that road?
Well, the thinking behind it. The reformers recognized that while talaq al-bina was considered wrong, it was happening a lot,
Hmm.
often in moments of anger or haste. Completely invalidating it might have caused other problems or just not been practical, given how widespread it was. So, by treating it as a single revocable talaq, they created a crucial cooling-off period. It gives the husband a chance to calm down, reconsider, and revoke the divorce during the iddah. It promotes family stability, essentially. The trend is really strong. Modern laws almost universally reject the idea that bidah forms, especially the triple talaq in one go, are immediately and irrevocably final. Unless, of course, it genuinely is the third separate talaq pronouncement in a sequence.
And alongside this, the source documents point to another huge trend, bringing talaq and divorce generally under judicial supervision, moving it out of the purely private sphere.
Yes, this is arguably the most significant procedural change in modern times. Many countries now mandate that talaq, and in fact, almost all forms of ending a marriage, have to go through the courts. It transforms divorce from what could be a very private unilateral act by the husband into a public supervised legal process. We see this in countries like Tunisia, Iran, Morocco, Malaysia, Jordan. Even Pakistan and Bangladesh have elements of this.
Can you give us a flavor of how this court supervision works, say in Tunisia?
Sure. Tunisia's approach is quite comprehensive. Their law basically says divorce only happens in court, period. Doesn't matter if it's by mutual agreement or if one spouse requests it unilaterally. A judge has to be involved. And the judge is actually required by law to attempt reconciliation between the spouses first. If the divorce does go ahead, the court then makes binding orders on all the related issues: maintenance, housing, child custody, and so on. Tunisia also has provisions for compensation if the court finds the divorce was initiated, say by the husband, without a really good cause causing harm to the wife.
And Iran. It has a Shia background, so its journey must have been different, but still towards the courts.
Absolutely. Iran's journey is fascinating. It moved from that traditional Shia view where the husband could pronounce talaq without court involvement towards making judicial process mandatory. There were various reforms, but the 1992 Divorce Act really cemented it. It required that all divorces must be processed judicially. You need a court-issued certificate of irreconcilability, whether it's the husband or the wife petitioning. And a really key protection for the wife in Iran under Article 3 of that 1992 Act is that the actual execution and registration of the divorce decree is often made conditional. Conditional on the husband first paying all the wife's financial dues, like her dower and mahr, and any outstanding maintenance. This requirement for payment before the divorce is finalized, it gives the wife significant practical leverage. The National State Distribution Council and EDC rulings have reinforced this.
Okay, other places like Pakistan and Bangladesh also involve courts or authorities, but maybe in a different way. I remember something about giving notice.
Yes, that's under the Muslim Families Laws Ordinance in 1961, the MFLO. It applies in both Pakistan and Bangladesh. Under Section 7, a husband who pronounces talaq must give written notice to a local government official, the chairman of the Union Council, and he must also send a copy to his wife. Failing to give this notice is actually punishable. It can lead to imprisonment or a fine, or both. Now, there's been a bit of a legal divergence on the effect of not giving the notice. The Pakistan Supreme Court, in a case called Allah Raqqa v. the Federation of Pakistan, back in 2000, ruled that while failing to notify is punishable, that the talaq itself is still effective from the moment it's pronounced. However, in Bangladesh, they tend to follow an earlier ruling, Ali Nawaz Gardezi v. Muhammad Yusuf from 1963, which held that the talaq is actually ineffective unless and until that notice is given. So the notice is mandatory for validity in Bangladesh. But either way, the requirement to notify authorities and the wife introduces that element of public record and oversight, which was absent in the purely classical model. Section 7 also introduces a 90-day waiting period after notice before the divorce is final, allowing time for revocation. Though the Allah Raqqa case in Pakistan declared that specific waiting period part repugnant to Islam, The notice requirement itself generally stands.
So, across the board, different mechanisms, but a clear theme of more judicial or state involvement. What about the husband delegating his right? You mentioned that briefly.
Yes, tafwid al-talaq. The husband can delegate his right to pronounce talaq to his wife. This could be done in the marriage contract itself or later. He can give her a general right to divorce herself or make it conditional, like, if I take a second wife without your permission, you have the right to divorce yourself. If the condition occurs, or if she has the general right, she can then exercise it and dissolve the marriage. It's a way for the wife to have the power of talaq.
And India took a very direct approach to the instant triple talaq, didn't it?
It did. The Indian Supreme Court case, Sher Bano v. Union of India in 2017, is landmark. The court declared the practice of instantaneous triple talaq, saying talaq, 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 all at once to be unconstitutional and effectively banned it in India.
Okay, so talaq, historically, the husband's unilateral power, now increasingly channeled through courts with limitations on things like instant irrevocability. Let's flip the coin. How can the wife initiate a divorce? What about kul?
Right, cool. This is a major way a wife can seek dissolution. Essentially, cool is the wife discharging herself from the marriage contract. It's fundamentally based on a mutual agreement between the husband and wife. Typically, the wife initiates it by offering some form of compensation to the husband in return for him agreeing to release her from the marriage. Usually, this compensation is returning her dower, the mar, that she received or was promised, or maybe forgiving the debt if it wasn't paid.
So it sounds a bit like the wife is buying her way out of the marriage.
That's a common way people understand it, yeah. While classical sources discourage the husband from demanding excessive compensation, especially if the fault for the breakdown isn't the wife's, legally speaking, the amount of compensation is whatever the two parties agree on. The effect of a valid khulz is an immediately irrevocable divorce. But, like the single talaq after the iddah, it's irrevocable only to the lesser degree, meaning they can remarry each other later if they both want to with a new contract. No intervening marriage needed.
You said it's based on mutual consent, but the source materials mention the Maliki school had a different angle, one that really influenced modern laws.
Exactly, that's a key point.
Yeah.
Classically, most schools insisted on the husband's consent for khul to be valid. If he didn't agree, it couldn't happen. But the Maliki school developed a unique concept, judicial khuls. This is where a court steps in. It happens when a wife following the Maliki school petitions the court for divorce based on dar, which means harm, injury, or prejudice within the marriage. Dar, as a ground for the wife, was particularly recognized by the Malikis. If the court agreed there was dar, it could grant the divorce as a judicial khuls, usually requiring the wife to pay compensation, often returning her dower.
So, under Maliki law, a wife facing harm could potentially get a divorce from the court even if her husband refused, as long as she was willing to give up her dower or pay compensation.
Precisely. It provided a crucial judicial pathway for women facing hardship, based on the principle of no harm in Islam. And this Maliki idea, a court granting a divorce initiated by the wife, often linked to grounds like harm and potentially involving compensation, has been incredibly influential. Many modern legal reforms across the Muslim world have drawn inspiration directly from this Maliki concept, allowing women to seek dissolution through the courts when mutual consent for khuls isn't forthcoming.
Which leads us nicely into the third main category, judicial divorce, often called fasq.
Right, so given that the primary unilateral right of talaq rests with the husband in classical law, a wife who can't get her husband to agree to khul and hasn't been delegated the right of talaq tafladum generally needs to go to court to seek dissolution. This is often termed fasq, which means annulment or rescission of the marriage contract by a judge.
And unlike the husband's talaq, for fasq, the wife needs to prove specific reasons, specific grounds to the court.
Yes, absolutely. That's the critical difference. The wife petitioning for fasq has the burden of proof. She must convince the judge that specific, legally recognized grounds for dissolving the marriage exist, and what those grounds were historically varied quite a bit between the different schools of law.
How much did they vary? Were some schools tougher on wives seeking divorce than others?
Oh, definitely. The Hanafi school, which was historically dominant in places like the Ottoman Empire and the Indian subcontinent, was traditionally the most restrictive for wives. Classically, the main ground they recognized for a wife to get a fasq was the husband's inability to consummate the marriage, basically impotence. If the marriage had been consummated even once, the wife generally had very limited, if any, recourse to the court for other problems, like abuse, desertion, or failure to maintain. This caused significant hardship and was a major driver behind early 20th century family law reforms in many Hanafi regions. The other major Sunni schools, Maliki, Shafi'i, and Hanbali, were generally more favorable to women. They recognized grounds like the husband having serious physical defects, like insanity, leprosy, certain diseases that arose after the marriage, in addition to impotence. They also typically allowed dissolution for the husband's failure to provide maintenance or for desertion for a prolonged period. The Maliki school, as we mentioned, was particularly notable for also allowing divorce based on that broader ground of darar or harm.
So, the modern reforms we see, they often involved countries adopting the more liberal grounds found in schools like the Maliki school, even if the population traditionally followed the Hanafi school.
Exactly, that's a major theme. Lawmakers looked at the different schools and often incorporated the more expansive grounds for judicial divorce found in Maliki, Shafi'i, or Hanbali law to provide greater relief for women. A prime example is the Dissolution of Muslim Marriages Act of 1939, the DMMA, enacted in British India. The population was largely Hanfi, but this act explicitly drew upon Maliki jurisprudence to give wives statutory grounds to seek divorce.
What were some of those key grounds in the DMMA in 1939? It sounds like a really important piece of legislation for women's rights in the region.
It was landmark. For students, knowing these grounds is crucial. Key ones include the husband's whereabouts being unknown for 4 years, the husband neglecting or failing to provide maintenance for 2 years, the husband being sentenced to imprisonment for 7 years or more. Also, his failure to perform marital obligations for 3 years without reasonable cause, the husband being impotent at the time of marriage and continuing to be so, the husband being insane for 2 years or suffering from leprosy or a virulent venereal disease. Cruelty by the husband was another major ground, and it also codified the option of puberty, Kher al-Balu, allowing a girl married off before age 15 to repudiate the marriage before turning 18, provided it hadn't been consummated. Plus, a catch-all, any other ground recognized under Muslim law.
Wow, that's a comprehensive list compared to just impotence. And Pakistan later saw significant court decisions relating to Kul specifically, right? Building on this idea of judicial dissolution.
Yes, Pakistan's jurisprudence on judicial Kul is very important to understand. The really pivotal case is Khurshid Bibi v. Muhammad Amin, a Supreme Court decision from 1967. Remember that name, Khurshid Bibi. The court did something quite revolutionary. It looked at the Quranic verse about Kul, Surah 2.229, which mentions, if you fear that they, the spouses, may not be able to keep the limits ordained by Allah. The court interpreted you, not just as the spouses, but as referring to the judge or the court. So the court held that if the judge determines that the parties can no longer live together within the limits prescribed by God, basically, if the marriage has irretrievably broken down, then the court itself can dissolve the marriage by granting a judicial Kul. This happens even if the husband doesn't consent, but it usually requires the wife to return her dower or other benefits she received. This Khurshid Bibi ruling effectively gave Pakistani women a ground for divorce based on irretrievable breakdown, assessed by the court under the umbrella of Kul.
And that interpretation evolved even further.
It did. Another key case to know is Naseem Akhtar v. Mohammad Rafiq from the Supreme Court in 2006. Naseem Akhtar. This case seemed to take it a step further. The court suggested that the very act of a wife filing a suit for Kul and stating her aversion to the husband could be sufficient evidence of the irretrievable breakdown. The implication was that if a wife insists she cannot live with the husband and wants Kul, the court should generally grant it. It shifted the focus more towards the wife's subjective inability to continue the marriage. Now, the issue of returning the dower is still there. But another important clarification came in cases like Aurangzeb v. Gulnaz, Karachi High Court 2006, Aurangzeb v. Gulnaz. This case held that while the wife is generally obliged to return the dower in a judicial Kul, the court can consider the husband's conduct when deciding the amount. And crucially, the court said that the dissolution of the marriage itself isn't conditional on the return of the dower. Once the court decides the marriage should end via judicial Kul, it is dissolved. The dower return becomes a separate civil liability the husband can pursue.
That's a really significant development. So judicial Kuls in Pakistan, shaped by cases like Khurshid Bibi and Naseem Akhtar, provides a powerful route for women, though the dower return is usually part of the equation. How does this compare with how Egypt handles judicial Kuls?
Egypt also introduced a significant judicial Kuls procedure with its Law No. 1 of 2000. It's become a very common way for women to seek divorce there.
Under the Egyptian law, if reconciliation attempts fail, a wife can petition for khul. She has to explicitly state she is relinquishing all her financial rights, like deferred dower, post-divorce maintenance, and she must offer to return the advanced portion of her dower that she received. The procedure involves a mandatory reconciliation attempt by the court, lasting up to 3 months. If that fails, and the wife formally declares before the judge that living with her husband has become repugnant to her and she fears she cannot keep within the limits of God, the court must grant the divorce by judicial khul.
So the key difference seems to be who makes the determination about living within the limits. In Pakistan, after Khurshid Bibi, it's the court deciding based on breakdown. In Egypt, it's the wife's declaration that compels the court to grant the khul.
Exactly, that's a crucial distinction. In Egypt, the woman's formal declaration of inability to live within the limits, coupled with her offer to return dower and forego rights, essentially mandates the court to grant the divorce. In Pakistan, while Nasim Akhtar gives great weight to the wife's plea, the underlying principle from Khurshid Bibi is still the court's assessment of irretrievable breakdown.
Got it. Okay, beyond talaq, khul, and fasq, the source materials briefly touch on a few other methods, though they seem less common now.
Right. Things like ella, zihar, and liyan. Ella involves the husband taking a vow to abstain from sexual relations with his wife for 4 months or more. Classically, this could lead to automatic divorce, Hanafi, or allow the wife to petition the court, other schools. Zihar is when a husband offensively compares his wife to a close female relative like his mother. This makes relations unlawful until he performs an act of expiation. If he didn't, the wife could potentially seek divorce. And liyan is a procedure involving mutual oaths, when a husband accuses his wife of adultery without the required 4 witnesses or denies paternity of her child. The oaths themselves could traditionally dissolve the marriage. These methods are now mostly obsolete in practice, though you might find them mentioned in some older codes or as specific grounds in limited contexts. For instance, liyan, or rather the husband falsely accusing the wife of adultery, was added as a ground for the wife to seek divorce under the DMMA in Pakistan through a 2006 amendment.
Okay, final major area. What happens after the divorce regarding financial support? What's the traditional view on maintenance?
Traditionally, the husband's duty to provide maintenance, nafaka, was seen as reciprocal to the wife's obedience during the marriage. So, once the marriage ended, that obligation generally ceased after the Ida period finished. The Hanafi school was a bit of an exception, requiring maintenance during the Ida even for an irrevocably divorced wife, arguing the Ida itself served the husband's interest regarding certainty of paternity. Other schools, and the Shia view, generally held that for an irrevocably divorced wife, the husband only needed to provide accommodation during the Ida and maintenance only if she was pregnant until she delivered.
But here, too, modern laws have stepped in to provide more support.
Yes, definitely. Recognizing that a wife, especially one divorced arbitrarily by her husband without good cause, could face real hardship, many modern laws have introduced provisions for post-divorce financial relief. This often takes the form of muta al-talaq, sometimes translated as a consolatory gift or compensation for arbitrary divorce. It might be a lump sum or maintenance payments for a specific period after the Ida. Countries like Syria, Egypt, Iraq, UAE, Yemen, Kuwait all have provisions for muta, typically awarding maintenance for, say, 1 to 3 years, depending on the country and circumstances, especially if the husband initiated the divorce without just cause. Tunisia, again, has particularly detailed provisions for post-Ida maintenance, making it potentially long-term and adjustable based on the former wife's needs and the former husband's needs.
And the situation in India around post-divorce maintenance for Muslim women became famously controversial, didn't it?
Extremely so. It revolves around 2 major Supreme Court cases and subsequent legislation. The first big one is Molad Ahmed Khan v. Shah Bano Begum, decided in 1985. Just remember Shah Bano. Mrs. Shah Bano, an elderly divorced Muslim woman, sought maintenance from her former husband under the Section 125 of India's Code of Criminal Procedure, a general law applying to all citizens, allowing destitute wives, children, parents, and significantly divorced wives unable to maintain themselves to claim maintenance. Her husband argued he only owed her the dower and maintenance during Ida, as per Muslim personal law. The Supreme Court ruled in favor of Shah Bano. They held that Section 125, being a secular law aimed at preventing destitution, applied to Muslim women too. They also made a controversial statement suggesting that Muslim personal law itself actually supported post-divorce maintenance.
And that ruling caused a huge backlash.
It did. Many conservative Muslim organizations protested, viewing it as interference in their personal law and religious freedom. The political pressure was intense. The government responded by passing the Muslim Women Protection of Rights on Divorce Act in 1986. This act essentially tried to take Muslim women out of the purview of Section 125, unless both parties agreed to use it. Instead, the 1986 Act stated that a divorced Muslim woman was entitled to a reasonable and fair provision and maintenance to be made and paid to her within the iddah period by her former husband, unquote. This wording, within the iddah period, caused huge confusion. Did it mean maintenance payments only during the iddah, or did it mean a one-time lump sum payment sufficient for her whole life that just had to be paid before the iddah ended? High courts gave conflicting rulings.
So how did they finally resolve that ambiguity?
That came with the second landmark Supreme Court case, Daniel Latifi v. Union of India, decided in 2001. Remember Daniel Latifi. The court upheld the constitutional validity of the 1986 Act, but crucially it interpreted that phrase, reasonable and fair provision and maintenance to be made and paid within the iddah period. They ruled it meant the husband must make a reasonable and fair provision for the wife's future needs and pay this as a lump sum during the iddah period. It wasn't just maintenance for the iddah period, but a provision for her future, paid within that time frame. So the effect was to ensure potentially significant post-divorce support for Muslim women unable to maintain themselves, but framed as a lump sum payment settled early on, rather than ongoing monthly payments under Section 125. These two cases, Shahbano and Daniel Latifi, alongside the 1986 Act, are absolutely central to understanding this issue in India.
Wow. Okay, we have certainly covered a huge amount of ground. We've traced the main paths, talaq, the husband's repudiation, seeing how it's been increasingly constrained by reforms and judicial oversight. Then khul, the wife's release, often involving compensation, and the crucial development of judicial khul. And fasq, judicial divorce sought by the wife, with massively expanded grounds in modern law thanks to inspiration from schools like the Maliki. And finally, this complex and evolving picture of post-divorce financial support.
It really does show the dynamism, doesn't it? When you connect all these threads, you see this ongoing interplay between the classical legal principles, the differing interpretations by the juristic schools over centuries, and then these contemporary legislative and judicial reforms, all trying to grapple with changing social realities, seeking fairness, practicality, and protection for spouses within an Islamic legal framework. It really highlights the evolution of law in response to societal needs.
It absolutely gives you a much richer, more nuanced understanding than just a simple definition of divorce. So, thinking about all this, what does it really mean for the balance of power, for the rights and realities of spouses navigating the end of a marriage in different Muslim contexts today?
That's really the big question to ponder, isn't it? How do these different approaches we see across various countries, the level of judicial control over talaq, how accessible judicial khuls is, the breadth of grounds for fasq, the generosity or limitations of post-divorce maintenance, how do these reflect different societal priorities or maybe different interpretations of those core legal principles? What does this divergence, this variety in reforms tell us about how different places are trying to balance individual autonomy, particularly the husband's traditional rights, with the need for judicial oversight, fairness, and the protection of potentially vulnerable spouses in the modern world?
Definitely leaves you with a lot to think about. It's clear this is a living, evolving area of law. Once again, our sincere thanks to the University of London for making these valuable source documents available for educational use. This deep dive was brought to you by Sinorbit Academy, Sri Lanka. And truly, best of luck to all students preparing for your exams.